Good evening, friends. A warm welcome to all. Today, the webinar is on recent changes in labor laws. Labor law mediates the relationship between workers, employing entities, trade unions, and the government. Collective labor law relates to the triple relationship between employee, employer, and union. Individual labor law concerns employees' rights at work also through the contract for work. The government introduced two separate labor codes on industrial relations, occupational safety and health, and social security. The initiative of bringing transparency and accountability through codification of labor laws will bring ease of compliance to the industry and investment push for India. It also provides a legal framework for fixed-term employment and ease of firing of contract workers. The given operational freedom will facilitate the expansion of establishments and job creation across different sectors. And for this, we have a guest speaker, Advocate Girish Patwardhan ji and Ankita Verma ji. He is a Generation 3 lawyer of a lawyer's family. His grandfather set up practice in labor law in 1946 and the legacy continued from his grandfather to his uncle Shri Harat Patwardhan and from his uncle to him. He has been appearing in industrial tribunals, High Court, Tribunal and Supreme Court. He was the president of the Labor Law Practitioner Association in Door. He was president of the MP High Court Bar Association in Door. And we have with us none other than CA Vivek Khuranaji, founder of CA Sansaar, and his name is just enough for the CAs. Now, I would request him to welcome him and give him a welcome address. So please.
Thank you, Stuti ji. Respected Advocate Girish Patwardhan ji, speaker of today's webinar, CS Stuti Mahajan ji, Ankita Verma ji, all other respected member of the profession. A warm welcome to all of you at today's webinar on recent changes in labor law. I hope everybody is fit and fine, and we professionals are either a chartered accountant, company secretary, cost accountant, advocates. They are very much busy in the income tax or the GST work. Even we can say that कि GST ने सबको ही busy कर दिया है. Nobody have that time. And in fact, recently our Modi government brings new labor codes, many changes in the labor law, and we have received many requests to organize a webinar on the recent changes in labor law. And we have very renowned, very respected faculty with us, Girish ji. My sincere thanks to Advocate Girish ji for accepting our invitation and giving your valuable time. So now it's over to you. Please guide us, our member, regarding the recent changes in the labor law. So once again, my sincere thanks to you, sir.
Thank you all. Thank you so much. फ्रेंड्स, आप सभी को मेरा नमस्कार और विवेक जी, स्तुति जी को मेरी ओर से धन्यवाद. उन्होंने मुझे इस लायक समझा और मुझे इस वेबिनार में आमंत्रित किया. थैंक यू सो मच. अगर हम मध्य प्रदेश की, अगर हम इंडिया की बात करें तो इंडिया में जो लेबर लेजिस्लेशन है वो अंग्रेजों के जमाने से जो चला आ रहा था वो अभी तक चल रहा था. There was no change in that. Years together, there was a demand from all the sectors, from the sector of workmen as also from the employers, to make changes in the labor enactments. And therefore, this piece of legislation has come up. We were expecting that while enacting these new codes, something new, something very fresh will emerge. But unfortunately, what has happened, while introducing these codes, only mixing of code has been done, and the principal activity which we were expecting that it will bring about a very major change in the approach, that has not come. But okay, something has started, so we'll pray that let us see, and I think later on there may be some changes by the government. So we'll take an overall look at all this. Let us start with first enactment, that is called Industrial Relations Code 2020. This enactment will replace three enactments: Industrial Employment Standing Orders Act 1946, Industrial Disputes Act 1947, and Trade Union Act 1926. These are the three activities, three enactments which were governing the field of employer and employee, industrial peace, industrial harmony, industrial dispute, and all things connected therewith. So there is these three enactments will go, and that will be replaced by this Industrial Relations Code 2020. Instead of taking you through the entire amendments and the new provisions of Industrial Relations Code 2020, what I will be doing, I will be showing you the key changes which have been brought about in the enactment, and on that basis, we will try to understand what is the intention behind this. So this is the first legislation is Industrial Relations Code 2020. The next is Occupational Safety, Health and Working Condition Code 2020. It is commonly known as OSH and WC Code 2020. This code will replace a number of enactments: Factories Act, Mines Act, Dock Workers Safety, Health and Welfare Act, Building and Other Workers Regulation of Employment and Condition of Service Act, Plantation Labor Act, Contract Labor Regulation and Abolition Act, Interstate Migrant Workmen Regulation of Employment and Condition of Service Act, Working Journalist and Other Newspaper Employees Condition of Service and Miscellaneous Provisions Act, Working Journalists Fixation of Rates of Wages Act, Motor Transport Workers Act 1961, Sale Promotion Employees Condition of Service Act, BD and Cigar Workers Condition of Employment Act, Cine Workers and Cine Theatre Workers Act. So this is category 2, and the category 3 is Social Security Code, which will replace EPF, that is Employees Provident Fund and Miscellaneous Provisions Act 1952, ESI Act 1948, Maternity Benefit Act, Building and Other Construction Workers SACE Act, Payment of Gratuity Act, Employees Exchange Compulsory Notification of Vacancies Act, Cine Workers Welfare Fund, Unorganized Workers Social Security Act, and Employees Compensation Act. So this is the category 3, which is going to which will be replaced by Social Security Code. So now let us proceed to see the key changes which have been brought about in these codes, under these codes. The key changes will be, if we see the definition of worker, it will be based upon the basis of wages being drawn by him, and at the same time the work discharged by him. The salary up to 18,000 will fall under the category of worker, and at the same time government has a right to enhance it by a simple notification. It can be enhanced to any amount. So this is the first change which is being brought about in respect of definition of worker. Fixed term employment is a new thing which has come under the code. The Standing Orders Central Act had introduced this provision about an year back in the Standing Orders, but now it is part of this industrial code, and now employee can be appointed for a specific period. Specific period means you can appoint a person for a period of 3 years, 4 years, 5 years, whatever you and the employee decide. And at the end of that period, the employer will not be required to pay retrenchment compensation to the worker. So that is a very major change which has been brought about in the definition of employee and fixed term employment. The important aspect will be that if this person has worked even for a period of 1 year, even in that case, the employee will be entitled to gratuity, which otherwise is payable to the employee after working for a period of 5 years. The next will be employee can raise an industrial dispute within period of 2 years. Previously, it was a limitation of 3 years was provided in the Industrial Disputes Act, but now it has been reduced to 2 years. Every trade union will have to give a notice before going on strike 14 days advance notice will be necessary. Previously, there was a provision that only in respect of essential services the notice was mandatory, but now it has become mandatory in every case. In establishment which are employing 300 or more, a permission from state government for effecting any layoff, retrenchment compensation or closure is required to be taken. Uh, if the industry is employing less than 300, in that case, the employer at his sweet will can effect layoff, retrenchment and closure. Previously, the definition was having a threshold limitation of 100 employees. Now that has been raised from 100 to 300. Thereafter, a major change is industry which is having more than 100 employees will have to have a works committee. The definition of appropriate government has been modified. There was a dispute which used to go on in respect of contractor. If a contractor is a state is having his registration under Shop and Establishment Act in a state and was giving services in a establishment for which appropriate government is central government, then there used to be a fight on that. So now that clarification has come, and the appropriate government will be the central government if he is working in a sphere of central government. If he is working in a sphere of state government, the appropriate government will be state government. The another key change which we can find from these provisions is the appropriate government shall set up a reskilling fund, and that fund shall consist of contribution by an employer equal to 15 days wages last drawn by the worker immediately before retrenchment. The fund shall be utilized by crediting 15 days wages last drawn by the worker to his account who is retrenched within 45 days of such retrenchment, in addition in such manner as may be prescribed. अब आप ये देखेंगे कि जो गवर्नमेंट के पास रिटेंचमेंट की सूरत में कोई पैसा अलग से जमा नहीं होता था, लेकिन अब इस चेंज की वजह से जो रिटेंचमेंट कॉम्पेंसेशन नोटिस पे और ग्रेच्युटी का पेमेंट तो एम्प्लॉयर को करना है, इसके अलावा एक 15 दिन का एडिशनल पेमेंट सरकार के पास जमा करना है, और उस 15 दिन की का जो वेतन है इसका बंटवारा करने का काम सरकार करेगी, और वो उसको किस तरह से किया जाएगा इसके बारे में अभी रूल्स आएंगे। उन रूल्स पे तय होगा कि ये बंटवारा किस तरह से होगा। कोशिश ये की जा रही है कि 15 दिन के अंदर 45 दिन के अंदर ये जो 15 दिन की तनख्वाह है इसका भुगतान किया जाए। एक नया चेंज जो है वो है कि इसमें एम्प्लॉय और वर्कर ऐसी दो डेफिनेशन दी गई है, ये पहली बार हुआ है। Definition of employee has been added in the code, and the term employee has been used invariably with the term worker, that is employee oblique worker or employee and worker, with a view to ensure that there is no discrimination in the applicability of labor law to the employee and worker employee. Reason being, in some plants the employers were making discrimination amongst the worker and employee, saying that the provisions of this particular provision is applicable to a worker and not to an employee. So now that would not be possible, and it will apply to both of them. The definition of employer has been completely modified under section 2M, and as per new definition, the employer means head of the department, occupier of factory. That is very important because under the Industrial Disputes Act, the occupier was not covered for anything. In fact, the word occupier is not defined anywhere in the enactment. But now this new act specifies that employer means occupier of the factory. Manager of the factory under clause F of subsection 1 of section 7 of Factories Act. The person who or authority which has ultimate control over the affairs of the establishment, and where the said affairs are entrusted to a manager or managing director, such manager or managing director. Very importantly, a contractor the definition, the Industrial Dispute Act was not recognizing a contractor as employer, but now the definition specifies that even a contractor will fall within the definition of employer, legal representative of a deceased employer. Fixed term employment which has been incorporated, the major change introduced in the code provide that the fixed term employee will get all statutory benefits like ESI, EPF, bonus, wages at par with regular employees who are doing work of the same or similar nature. That is very important. That goes to suggest that if you will not be able to exploit an employee, a worker, if he is appointed as a fixed term employee, and he will be entitled to all benefits which are payable to another fixed term employee, another regular worker or full time worker. So the benefits like statutory benefits like ESI, EPF, bonus, all will be applicable to them. The only thing is his day of exit is decided on his day of entry, because it is a fixed term employment. So if he is appointed for a period of 3 years, his date of exit is already decided, and therefore it will not be treated as a retrenchment, and therefore he will not be entitled to any retrenchment compensation or notice pay. But though he may not have worked for a period of 5 years, yet he will be entitled to provisions like gratuity and other benefits. The definition of industry has been modified and provide that any systematic activity carried on by cooperation between employer and his worker, whether such workers are employed by such employer directly or by or through any agency, including a contractor. The definition has specifically excluded institutions owned and or managed by organization wholly or substantially engaged in any charitable, social, or philanthropic services, sovereign functions, and domestic services. So this is the definition. If you will recall, there was a very major judgment by Supreme Court. It was by a very almost 9 judges bench judgment by the Supreme Court in the matter of Bangalore water supply versus A. Rajappa. That is a very celebrity case which very oftenly referred in as in when a question arises whether this is an industry or not. So the definition which was evolved by Justice V.R. Krishna Iyer, in that definition, that has been picked up and included in the present thing. So that is the same definition which has been taken up from that Bangalore water supply judgment. The definition of industrial dispute has been modified to include the disputes regarding discharge, dismissal, retrenchment, and termination of such worker. Previously, there was a bit controversy going on in respect of industrial disputes. For some disputes, that dispute was required to be sponsored by a union. Now that requirement has been completely taken away. So an individual employee can raise a dispute and take up his matter before the court of law. Metro railway has been included in the definition of railways. Maximum number of members in grievance redressal committee has been increased from 6 to 10 in an industrial establishment employing 20 or more workers. So now, if the industry is having 20 or more, then there will be a grievance redressal committee that is called a GRC, which will operate, which will represent the workers. If the industry is employing 100 or more workers, then there will be a works committee that will operate. A very important change which has been brought about by virtue of this industrial code, industrial relations code, is introduction of negotiating union or negotiating council. The negotiating union is will be a union which is having 51% membership in the plant, in the factory. If any union is not having, if no union is having 51% membership, in that case, it will be seen that whether the union is having 20% membership or not. And all the unions which are having 20% membership will be given a representation, and then a council will be formed that will be called as negotiating council. And this negotiating council will have discussion with the management. If there is a union which is having 51%, then that union will be entitled and eligible to have negotiation with the employer. So this is a new concept which was already there in some states like Madhya Pradesh, Gujarat, and Maharashtra. In I think in Rajasthan also. In these states, they were having their representative characters in under Industrial Disputes Acts also, or in State Act, which were named as Madhya Pradesh Industrial Employment Standing Orders Act, or MRTU and PULP, Maharashtra Recognition of Trade Union and Unfair Labor Practices Act, or in Gujarat, the same Bombay Industrial Relations Act, which was adopted in the state of Gujarat. They all these acts were having representative union provision. Now that has been inserted in the Industrial Disputes Act. The trade union disputes have been added, which provide disputes relating to trade union arising between two or more trade unions and between members of a trade union. So that is also as and when the dispute regarding negotiating union or who will negotiate, who will represent the employees will come, the dispute between one trade union and another trade union are also going to rise, and therefore now that this has also been covered under the definition of dispute. The definition of wages has undergone a very important change, and that important change is now the category 1 is basic salary, DA, and returning allowance. The second part of the definition is bonus, which is excluded. That is bonus payable under any law, conveyance allowance, house rent allowance, overtime allowance, house accommodation, supply of light, water, medical attendance, and other amenities, commission, contribution to PF, pension, any sum paid to defray special expenses, gratuity, retirement compensation, payable under any award or settlement between the parties. And the third very important aspect is the total excluded component should not exceed 50% of total remuneration. The third part of definition provide limit, as the definition very clearly specifies the list of exclusion. So anything which is paid to the employee other than exclusion would be covered. And with this specific exclusion, the limit cannot be more than 50%. Let me give an example. The if an employee is getting salary that is basic plus DA in tune of rupees 10,000 rupees, and other amount which are payable to the employee are are also 7,500 rupees. Say 7,500 rupees. That is inclusive of house rent allowance, conveyance allowance, house accommodation, and like that other allowances. So 7,500 is exceeding 50% of the total remuneration. In that case, 2,500, that is the excess part of 50%, will be added for the purpose of salary. So this is a new concept which has been brought about, and let us see how it will be accepted by the by the managements. I have already spoken about the recognition of negotiating union. So let us go further. The provision of standing order on industrial establishment will be applicable which have 300 or more than 300 workers as notified by the appropriate government. This is a very major change. Previously, the definition used to cover in all states there were different provision. In Madhya Pradesh, there was the provision regarding 50, which was thereafter raised to 100, and in other states it was 100 or more, but now it has been raised to 300. The code prohibits all strikes and all lockouts unless a notice of 14 days is provided, that has been given. The similar provision which existed in Industrial Disputes Act for public utility service such as railways, airlines, electricity boards, municipal boards, all those public utility services now those provisions have been made applicable to all industrial establishments, every industrial establishment. So now it can be said that workers will be the rights of workers will be hampered, and the right of employer to effect lockout will also be hampered. Let us see. An industrial dispute can voluntarily be referred to arbitration by the employer as also by the worker. The parties to the dispute are required to execute a written agreement referring the dispute to an arbitrator. This provision was already there in the Industrial Disputes Act under Section 10A. So it has been retained, and the same provision is there. The worker may approach industrial tribunal for adjudication of any dispute related to dismissal, discharge, or termination within 45 days from the date of application to the conciliation. It is also this provision was already there in the Industrial Dispute Act, that has been retained. The employer of industrial establishments such as mines, factories, and plantation with at least 300 workers are mandatorily required to take prior permission of central or state government before effecting any layoff, retrenchment, or closure. And for violation of any such provision, a fine of rupees 1 lakh to 10 lakhs has been provided. Previously, the fine was much less, but now under new enactment, it has been raised right up to 10 lakhs. In case any worker is suspended pending inquiry, which is most common when we serve a workman with a charge sheet, normally he is placed under suspension. In standing order, this provision was already there, but in some standing orders, this provision was not there. So now it will be this provision will be applicable, which provide that for first 90 days, the allowance payable will be 50%, and thereafter 75% for the remaining period of suspension. So that is the sum and substance of Industrial Relation Code, which was introduced, which has already been passed. The draft rules have already been notified, and in a month, I hope that government is going to implement it. A very major change has also been brought about in the Industrial Relation Code is introduction of the Constitution of Industrial Tribunal has been changed. Previously, there used to be a presiding officer, but now that presiding office, along with that presiding officer, there will be a member who will be called as member administration. So it will be a two-member bench which will adjudicate the disputes between the parties. In one way, it will help to decide the matters promptly, easily, and with acceptability to the public at large. Because the view of a judicial officer alone will not be there. A person of the rank of deputy secretary has been provided to sit as member administration on the bench of this industrial tribunal. Now we go to the next, that is social security, social security code. And the most important definition, the key change which has been brought about is gig worker. Gig worker is a person who performs work or participates in work arrangement and earns from such activity outside of traditional employer-employee relationship. Gig worker is an independent arrangement, freelancer worker who are employed on project-based work or short-term work. Platform-based work where workers earn money by providing specific service, including food delivery. So all the persons who are doing the work of Zomato or delivering the Ola or Ola drivers or like app-based services, all those workers were deprived of the uh, provisions of all security schemes, social security schemes. To cover all of them, a very important aspect has been taken into consideration by the government, and this gig worker or platform worker has been introduced. So it's a very important change, and we must welcome that. I will not bother you again taking you through the definition of wages, which has been introduced in Social Security Code, because the definition of wages is common in all the three codes, and it has been taken from the Code on Wages, which was already passed and notified in the year 2019. It is the same definition. The only important part which I want to bring it to your notice, there was a judgment of Supreme Court in the matter of Vivekananda Vidya Mandir versus RPFC. In that case, a view was taken that HRA will not be the part of wages for the purpose of calculation of contribution under EPF Act. But now, as per this definition, if the 50% part is going above the excluded component is going up, exceeding the 50% of total remuneration, in that case, the employer will be required to pay house rent allowance on the basis of on HRA also, or any component which will be included in that. So it's a change which will have which will make hole in the pocket of employer. It's a very important aspect which is required to be taken into consideration. In ESI, there was already a provision that the ESI corporation will not be able to initiate any action for the period beyond 5 years. So now that has been introduced in EPF also. In EPF also, the EPFO organization will not be able to initiate any action after a period of 5 years in respect of any lapse. And a further period of 2 years has been provided for concluding the inquiries under Section 7A or 14B. Aadhaar based registration is has become mandatory. For applicability of PF, there were schedules, and the industries which are covered in the schedule were covered under the provisions of EPF Act. Now, as per new definition, every establishment in whichever activity it is engaged, if they are having 20 or more workers, it will be covered under the EPF. It is very likely that the rickshawalas or cart hand carts and all these activities may also brought under the purview of EPF. For that, necessary amendments have been incorporated in the act. Even previously, the penalty provisions in respect of violation of EPF provisions were there. Now they have been made more stringent, and penalty amount from has been raised from 10,000 rupee to 1 lakh rupee, and imprisonment from 1 year to 3 year for non-payment of contribution and non-deposit of contribution has been provided for. For subsequent failure to pay contribution, will have additional burden of imprisonment from 2 to 5 years and fine up to 3 lakhs rupees. So that is a very important aspect from CA point of view. I think you will take note of it, that any violation of or non-payment of PF will have very serious consequences. The another part is of employees' state insurance. The employer and majority employee agree that voluntary registration has been allowed under the code and ESI scheme will be applicable. So it is not necessary that they are having 10 or more employees. Even if they are having less than 10, even in that case, the provision of ESI can be obtained. The government can extend ESI scheme to any hazardous occupation if a single person is employed in that. The facility of ESI will be available to all 740 districts. Gig workers and organized sectors will also be able to link with ESI. This is a major step in respect of social security, providing social security to a section of worker which were deprived of various schemes. Plantation workers will also fall under the purview of ESI. If any employer fails to pay ESI contribution, even then ESI has to pass on the benefit to the employee, which ESI can recover from the employer to the extent of capitalized value of benefit net of the payment of contribution amount, interest and damages payable by the employer. So ESI corporation will not be able to take a stand that because the employer has failed to pay the amount of contribution, therefore we are not obliged to extend the benefit. That stand will not be available, and the employee will be benefited by the ESI, and he will be able to take all facilities in case of ailment for himself or for his family members. So far as gratuity is concerned, gratuity is payable on completion of 5 years, and for fixed term employee, as we have already discussed, the requirement of completion of 5 years will not be looked into. Now they are making it mandatory for again for the purpose of CAs for all chartered accountants. I must bring it to your notice. As and when this code will be brought into force, will be made applicable, they are going to provide for a scheme for some time, and thereafter they will make it mandatory to have an insurance, gratuity insurance in respect of employees who are working there. So that presently only LIC is giving such is selling such gratuity policy. I think thereafter other players will also come into market, and there will be big market of gratuity policies. So from your point of view, it will be a very important development. In respect of working journalist, the eligibility criteria for payment of gratuity has been brought down from 5 years to 3 years. uh, there is a discrimination in respect of worker and worker. For ordinary worker, the minimum working of 5 years is mandatory, but for a journalist, it is not necessary. Uh, you will see a very important new aspects have been brought into force. Employers, job seekers looking for vocational guidance, career counseling, self-employment, they all have to register themselves with the career centers, which will be established by the government. All establishments accept some inclusion like agriculture, domestic service, employment less than 90 days are required to be notified for notify the vacancies to the career centers electronically or otherwise. So this is a new thing which already after this migrant labor issue which started during this lockdown, and then government of UP, government of Bihar, government of Maharashtra and Madhya Pradesh, they all have set up some workers facilitation centers. On those lines, the government of India has also introduced a scheme that there will be a database in respect of employees who have been working uh, all over India, so that on the basis of that data available at the career center, the vacancies can be filled up. The employer will have to file a return to the concerned career center at the end of every year. So far as maternity benefit is concerned, there are no major changes in that. The change is every woman will be entitled to medical bonus up to 3,500, where before giving birth to a child, she will be entitled to that. And postnatal care is not provided by the employer, whose upper limit can be amended by the central government up to 20,000 rupees. And this can be, and this limit has been completely removed. So any employee will be covered by this definition, and everyone will be entitled to maternity benefit now. You might be aware that there is an enactment that used to be called as Workmen Compensation Act. In the year 2011, that definition was amended, and the name of the enactment was changed to Employees Compensation Act. There is another enactment which is called as Building and Other Construction Workers Act and Unorganized Workers Social Security Act. So for these these three things, a social security board will be created. Coverage of gig platform and unorganized workers under the ambit of social security will be brought in. Code to expand the sources of the fund for scheme to include funds from corporate social responsibility, that is CSR, and any other source as may be specified in the scheme, and also contains enabling provision for constituting special purpose vehicle for the purpose of implementation of schemes for unorganized workers. So this sector will be completely under the control of central government, and central government will introduce such new schemes as they deem fit. The the bill also make provision for registration of all three categories of workers: gig workers, platform workers, and unorganized workers. Unorganized worker is a very major chunk who are working in India. How it will be implemented is really a big question. That how they are going to register. all unorganized workers. So far as gig workers are concerned, platform workers are concerned, they can be registered, but it's very difficult that unorganized workers will be registered throughout India. Let us see how it goes. Contribution from an aggregator will be at the rate notified by government, which can fall between 1 to 2% of the annual turnover of aggregators. However, the maximum limit for such contribution fixed at 5% of the amount paid or payable by an aggregator to gig workers and platform workers. So now, till this moment, all these app-based activities were not covered by the definition of labor laws, but now they have been brought into the sphere of labor laws. The name of inspector has been changed from inspector to inspector cum facilitator, and he is expected and supposed to supply information and give advice to employers and workers concerning the most effective means of complying with the provisions of proposed code. All of you have experience of inspectors who have been inspecting the establishments, who have been paying visit to the to the establishments. What do they do? How they behave is known to all. Whether this new law is going to make any change in their attitude will be a very big question. Now we proceed to last last code, that is called OSH and WC code, Occupational Safety Health and Working Condition Code 2020. This code provides for single registration for an establishment instead of multiple registrations. It will design a centralized database and develop an ease of doing business. This is definitely a welcome step, and welcome step in respect of welcome step for all establishments. They will not be required to run through regards of one door to another for having registrations. One registration will take care of all registrations, and it will at the same time develop a centralized database, and it's a very important step on ease of doing business. Understanding orders in Madhya Pradesh, the appointment letter was mandatory. Now under this scheme also, they have made it mandatory to issue an appointment letter. For working women, the working hours engagement of a woman during night shift was not allowed. Now, with her consent, she can be appointed in night shift. The time slot for such night shift shall be from 7 p.m. to 6 a.m. and it has to be approved by central or state government. There are some other requirements. There will be some other requirements like uh, picking up a lady worker from her home and dropping the lady at her home, etc. That government, state government or central government, whosoever is the appropriate government, that will decide. They will frame the rules, and on that basis, it will be implemented. But the important thing is, on equality, applying the principle of equality, a woman has been permitted to work in night shift. The rights and duties of employee and employer are laid down, and the employees will take care of their own health, comply with the specified safety and health measures, shall report unsafe situation to the inspector. The offences and penalty under this code, an offence which lead to the death of an employee will be punishable with a imprisonment up to 2 years or fine up to 5 lakh rupees or both. Previously, it was 2 lakhs and imprisonment up to 2 years. Now it has been raised from 2 lakhs to 5 lakhs. The court chief inspector cum facilitator or inspector cum facilitator or an officer of the appropriate government or a person authorized to discharge any duty to exercise any power under this code has been granted a discretionary power wherein it may direct that at least 50% of such fine shall be given as compensation to the heirs of the victim. The code further states that where no penalty has been laid down for violation of the provision of code by the employer will be penalized with a fine between 2 to 3 lakhs rupees. And where the employee violates any provision of the code, he will be subject to a fine of rupees 10,000. So now the violation under this code are having very strict consequences. The fine has been raised up to 5 lakh rupees. The appropriate government for the factory governed by central government will be the central government, and for rest of factories the appropriate government will be state government. Very important aspect which has been brought about, a important key change can be said to be that audio visual production includes feature film, non-feature film, television, web-based serials, talk shows, reality shows, and under the new definition of audio visual worker, singer, news reader, dancer, stunt person, technical, artist, and work like supervisory, etc., have been covered subject to some wage ceiling that will be notified by the central government. So, a very important amendment has been brought about, which will cover a complete new sector, which will bring in a complete new sector under the sphere of labor laws. The definition of contract labor has been modified and includes interstate migrant worker, but excludes part-time employee, regularly employed and manually accepted standards of the condition of employment and entitled to social security benefits. The new definition of core activity provides that activity for which establishment is set up and other activity like housekeeping, security, canteen are not to be treated as core activity. The problem was as and when the dispute regarding absorption of contract labor used to come, the focus used to be on these activities, that is security, canteen, and housekeeping, because the requirement of these persons is continuous. 24/7 these workers give their service in the plant, and there is always a demand to abolish contract labor in respect of these activities. So now the government by this notification has completely taken away this activity from the core activity. Principal employer to provide welfare facilities where contract labor is deployed. That is, contract labor will be entitled to get welfare facilities from the principal employer. Principal employer shall be liable to make payment of wages to the contract labor deployed by him. The work hours for different class of establishment and employees shall be as per rules prescribed by state government or central government. In relation to overtime work, the employee shall be paid twice the rate of daily wages. It is the same. There is no change in that. The code in regard to leaves states that no employee shall work for more than 6 days in a week. There is no change in the previous provision. An exception has been provided for motor transport workers. The definition of employee has been incorporated and includes persons doing any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, or clerical work for hire or reward. This is the same definition which is presently there in the Industrial Disputes Act. It is the same definition. Uh, As per new definition of employer, a person who employs whether directly or through any person or on his behalf or on behalf of any person, one or more employees in his establishment. So I have underlined one or more. That goes to show that even one employee is engaged, that will make you an employer. And in that case, the employer will be head of the department, occupier of the factory, manager of the factory under clause 171F of Factories Act, owner of the mine or agent or manager, the person who or the authority which has ultimate control over the affairs of establishment, and where the said affairs are entrusted to a manager or managing director, such manager or managing director, contractor, and legal representative of a deceased employer. If you will recall, I have already read this definition in part two. This is the same. There is no change in that. So, by bringing in these definitions, they have tried to make a harmonious construction in respect of these definitions. All these definitions have been brought at par. Previously, there used to be different definitions. For example, I will tell you that the definition of wages was different in all enactments. Now there will be a one definition in respect of all the three codes, all the four codes rather, because code on wages, the definition of wages which is provided in code on wages has been adopted in all the three codes. The definition of factory has been revised under section 2W, and threshold limit is now 20 in case of use of power and 40 in case without power, and specifically excludes hotels, restaurants, eating places, electronic data processing units, or computer units. The definition of hazardous substance provide for any substance has potential to cause physical or health hazard to human being or other living creature. Uh, that was covered under section 2CB of Factories Act, that has been kept intact. New definition of industrial premises provide a premises in which any industry, trade, business, etc. is being carried on or with or without power, and includes a godown. Definition of interstate migrant worker has been modified and ceiling limit of 18,000 has been introduced. That is again at par with the definition of worker or employee which has been provided in first enactment, that is Industrial Relations Code. Definition of machinery has been inserted and excluded, includes any article or combination of article assembled, used, or intended to be used for converting any form of energy to perform work. Definition of manufacturing process has been taken from the Factories Act and provides such other processes as central government may notify. The definition of metro railway has been added, and metro railway have been treated as part of railways. Definition of newspaper establishment has been drastically changed and covers all type of establishments carried on by individual partner firms, body corporates, subsidiaries of a common holding company, etc. Definition of occupier has been amended, and instead of clause A, B, and C in proviso, a consolidated definition has been given. Definition of principal employer has been modified to the extent that employer manager has been excluded from the definition of principal employer. So previously, in the name of principal employer, the name of factory manager used to be given, and the person who is managing the affairs of the plant of the company managing director or executive director, they used to get benefit of those lapses. So now they will be covered and they won't be able to uh, go out of the clutches. That is the idea behind this. Definition of producer has been added, means a person who making arrangement for necessary production is also included. The definition of self-promotion employee has been revised, including a person in supervisory capacity, managerial or administrative capacity, getting salary up to 18,000 per month, as may be notified by central government from time to time. This is specifically applicable in respect of medical representatives who are working for pharmaceutical company, and for them a special act was provided, that is self promotion employees condition of service act. uh, for them this definition has been carved out. Definition of worker has been revised and it includes person in supervisory capacity and working journalist, self promotion employees getting salary up to 18,000 per month, or as the case may be notified by the central government, has been brought into. So this is an introduction to the enactments, to the changes which have been brought about, and the overall, if we see at the overall picture, it's not made any major difference, for the reason that it is only a mixture of all enactments has been done. But I will give you an example that when I was talking to a trade union leader, he told me that वकील साहब मुझे एक ये बात बताइए कि ये जो ईपीएफ ऑर्गेनाइजेशन है, ये इस ईपीएफ ऑर्गेनाइजेशन को चलाने के लिए इतने सारे अफसर, इतने सारे लोग काम करते हैं, इन लोगों की जो तनख्वाह है वो हमारा जो कंट्रीब्यूशन है उस कंट्रीब्यूशन के ऊपर इनकी तनख्वाह बनती है, और जो पेंशन हमें नहीं मिलती वो पेंशन इन लोगों को मिलती है। तो अगर ये डिपार्टमेंट खत्म कर दिया जाए और इस डिपार्टमेंट की जगह पे अगर ये पैसा एम्प्लॉयर और एम्प्लॉय का एक बैंक में जमा किया जाए, तो बैंक वाला इंटरेस्ट देगा, जो उसके पास जो पैसा बना रहेगा उसके ऊपर से वो पेंशन भी प्रोवाइड करेगा, और ये जो खर्चा है इतना बड़ा, इतने बड़े ऑर्गेनाइजेशन को चलाने का, वो सरकार का बचेगा। लेकिन अब ये एक ऐसा मैं उस बात से सहमत था कि ये बात सही है कि इसको चलाने के लिए बहुत बड़े इसकी जरूरत पड़ती है, लेकिन अब इसको किस तरह से रोका जाए और किस तरह से, तो मैं कहना ये चाह रहा हूँ कि जो एक प्रैग्मेटिक सोच होना चाहिए था ये अमेंडमेंट करने के पहले, वो प्रैग्मेटिक सोच नहीं आ पाया। एक ब्यूरोक्रेटिक अप्रोच ने इसको जो एक बहुत अच्छा जो एक मौका था इसे ठीक करने का, उस मौके को हमने गवा दिया। ये एक दुख की बात है। जो भी प्रश्न अगर आपके कोई हैं तो आप जरूर मुझसे कर सकते हैं इसके बारे में। अगर
कुछ क्वेरीज हैं।
जी जी जी
एक तो एस एन शर्मा जी की क्वेरी है, ए चार्टर्ड अकाउंटेंट फर्म हैज पार्टनर एज एम्प्लॉइज and other employees registered as MSME too. Other professions like legal management and architect etc. Will they be covered under this code?
अगर पहले पूछा जाता तो मैं जवाब देता कि नहीं, मगर अब जवाब दूंगा कि हाँ। इसका कारण ये है कि पहले चार्टर्ड अकाउंटेंट एक्ट का प्रोटेक्शन इन्हें अवेलेबल था, और इस कारण जो इंडस्ट्रियल डिस्प्यूट एक्ट है वो प्रिवेल नहीं करता। लेकिन अब चूंकि ये दोनों सेंट्रल एक्ट है, जो चार्टर्ड अकाउंटेंट एक्ट है वो भी सेंट्रल एक्ट है, और ये जो कोड है ये भी सेंट्रल एक्ट है, तो चूंकि ये सब्सिक्वेंट है इसलिए ये कवर करेंगे।
ओके। और सेम इन केस ऑफ सॉफ्टवेयर कंपनीज।
सॉफ्टवेयर कंपनीज जो है वो इस बात की खुशी मना रही है कि उनको फैक्ट्री एक्ट से बाहर कर दिया गया है, और इसलिए उनके ऊपर अब ये कोई प्रोविजन नहीं लगेंगे। लेकिन मैं इस बात का को से इसरार नहीं रखता। मेरा ऐसा कहना है कि ये सब कवर होंगे और सॉफ्टवेयर कंपनीज छूट नहीं पाएंगी, क्योंकि कवर कोशिश ये की गई है कि हर वर्ग को कवर किया जाए। तो ये कहा जाना कि सॉफ्टवेयर कंपनीज कवर नहीं होंगी, थोड़ा मुश्किल है।
एक और क्वेरी है, is individual contractor या professional services under section 194C or 194J all be terms as gig worker. ये आपने जो एक नया कॉन्सेप्ट बताया है जिग वर्कर का,
जी जी जी
तो ये हमारे टीडीएस में सेक्शन है 194C और 194J। 194C कॉन्ट्रैक्टर के लिए और 194J प्रोफेशनल्स के लिए।
नहीं, प्रोफेशनल के लिए तो कवर होगा, लेकिन
हाँ
जहां
हाँ,
तक इंडिविजुअल कॉन्ट्रेक्चुअल का सवाल है वो तो ऑलरेडी कवर्ड है ना, तो उसके लिए तो अलग से कुछ देखने की जरूरत ही नहीं है, वो तो कवर है ही, इन एनी
ओके
केस कवर्ड है जी।
ओके। So a really wonderful session, sir, and my sincere thanks to you for explaining all the provisions related to the recent changes in the labor's law, and we are thankful to you, and definitely will take your services more and more once this code has been implemented. Thank you.
थैंक यू विवेक जी, मैं एक बात कहना चाहता हूँ। ये
Yes,
जो
sir. Yes.
एक सवा घंटे का जो समय था, ये सवा घंटे का समय किसी एक कोड को लेकर उसमें बात करने का नहीं था, इसलिए मैंने
Exactly.
अभी आपको सिर्फ जो कोड है उनके बारे में क्या नई बातें आई हैं ये बताने
Yes.
में अपना समय लिया है। जब भी आप सोचें कि इन कोड के ऊपर बात करनी है, तो उसके लिए एक एक कोड को अलग अलग हमें डील करना पड़ेगा।
Exactly.
अ,
Exactly.
जब भी कहें, इसके लिए मैं हाजिर हूँ।
यस सर, यस सर, बिकॉज वी हैव द लिमिटेड टाइम और इस लिमिटेड टाइम में हमने चेंजेस जितने भी हैं वो ले लिए हैं। बट यस,
जी
यू आर राइट, अगर हमने किसी कोड पे स्पेसिफिकली डिस्कस करना है, दैट वी विल टेक कि जो नए कोड्स आए हैं उसके ऊपर पूरा कंप्लीट 1.5 वर्जन का, तो डेफिनेटली
जी
विल टेक योर टाइम इन फर्दर। सो वंस अगेन माय सिंसियर थैंक्स टू यू एंड थैंक्स टू ऑल ऑफ यू फॉर वाचिंग दिस लाइव वेबिनार। बाय बाय, टेक केयर सर। एक और क्वेश्चन है संतोष जी का,
जी
लास्ट में आ गया, चलो ले लेते हैं।
जी जी।
ESI can be optional if employee exceeds rupees 21,000 by employees.
हाँ, वो अभी आज की तारीख में तो वही है। अब वो गवर्नमेंट ने इस बार ये किया है कि ये जितने जो सीलिंग है, वेज सीलिंग जो है हर इनेक्टमेंट के, उनको बाय नोटिफिकेशन चेंज करने का प्रावधान अपने पास ले लिया है। तो वो
ओके
कभी भी जो है वो किया जा सकेगा, और गवर्नमेंट उसको एक्सटेंड कर सकेगी। तो अब वो जब नए रूल्स आएंगे इन कोड में, तो उसके अंदर ये पता चलेगा कि वो अब इसको आगे कहाँ तक ले जा रहे हैं। अभी आज की
ओके
तारीख में तो इतनी जा रही है
ओके ओके
जी।
ओके सर। So thank you very much, sir. Once again, my sincere thanks to you, and
सो
thanks to all of you.
नाइस
Bye bye. Take
जी।
care.